Hello everyone, good morning. My name is Filip Ludwin, I'm the Vice Rector for Education at Collegium Intermarium University and the Dean of the Faculty of Law. And today I have a great pleasure to introduce you Professor Ligia Castaldi from Ave Maria School of Law in Naples, Florida, who is our next foreign visiting professor. Professor Castaldi spent 3 weeks in Poland, almost 3 weeks, sorry, 18 days exactly, in Poland. During her stay, she was visiting Collegium Intermarium, she was observing our activity, she had some meetings with our staff, she gave some lectures, 30 hours of lecture, even 30 hours of lectures for our LLM postgraduate students. And right now, Professor Castaldi is finishing her stay in Poland. She's coming back in 2 days, but now Professor Castaldi is going to present you a short open lecture devoted to an extremely interesting topic. The topic is natural law and international law. So Professor Castaldi is going to underline some influences between natural law and international law. So in my opinion, the topic is perfect, and I'm waiting for what you will say. So thank you very much for your visit. Thank you very much for the whole stay, and I hope we will stay in touch, and we will continue our cooperation. So thank you very much once again, and the floor is yours.
Hello, everyone, and thank you for inviting me to give this guest lecture, open lecture for Collegium Intermarium. I chose a topic that I think would be interesting to the institutional mission of Collegium Intermarium, which is to promote natural law philosophy, a natural law philosophy approach to the law in every area, right? And to defend classical liberal values. So I thought one of the areas that has been often neglected is international law, and how natural law reflects itself on international law. So as, you know, a specialist, I would say, in this area, I have always believed that international law is one of the areas that most clearly reflects natural law principles and how they have become codified in international law. Natural law is not just something abstract principles and ideas, and the criticism by several academics against the natural law is that it is too imprecise to actually define concrete rules, right? That it is mostly aspirational ideas or moral values that are presented as an excuse to codify Christian morals into the law, right? Well, that's not a correct perception or a correct understanding of natural law principles. And international law actually does codify and has for a long time codified natural law principles, not as religious principles, but as moral principles that are inherent to the values of different nations, of different legal systems and legal traditions. So I wanted to just start at saying that the name given to natural law principles in international law is General Principles of International Law. So these are not just made up by academics, but these are actually codified in the ICJ statute, so the statute of the International Court of Justice, which contemplates 4 sources for international law. One of them is treaties and conventions, which is obvious. So those are the treaties adopted between nations. Another is customary international law, so the international customs that create norms with time, if accepted by the nations. And the third source is general principles of international law. Only after general principles come other non-binding sources, such as the writings of scholars, judicial decisions, which is very particular because in domestic law, judicial decisions can be very, very much binding, right, legally. Not in international law, however, jurisprudence of international courts does not have the same level of authority that general principles of the law do. And even after that comes soft law. So soft law is political agreements that nations reach in, let's say, international conferences, like, let's say, the International Conference on Population and Development in Cairo, or the International Conference on Women in Beijing, for instance. Those are soft law. So those have even less authoritative force or binding force under international law. So the existence of general principles of law inspired in the natural law, or even consisting in the natural law, has been recognized by the ICJ, so the International Court of Justice, repeatedly. For instance, in the Corfu Channel case, where this case involved a high seas collision between two ships, and the court in that case, the ICJ, found that they couldn't find a treaty norm that mandated providing assistance to injured crew members of the ships. So they based their finding on a general principle of international law, which they found was elementary considerations of humanity, right? And this was not only about giving assistance to the members of the crew, but also elementary considerations of humanity, not to place mines in an international strait without notice, right? So this was because two UK destroyers struck these mines, and there were several casualties among the crew members. So this has been recognized by the ICJ. It has also been recognized by the European Court of Justice. The existence of these principles, for instance, in the AM&S case, the European Court of Justice recognized the existence of a regional principle of international law that protected attorney-client privilege, the attorney-client privilege, meaning confidentiality of documents exchanged between a client and his or her attorney, even though this was not codified as such in every single European state, right? So these are just some examples of how courts have recognized them, and not just courts, but actual instruments of human rights law. For instance, you may know about the UN Declaration of Human Rights. So this is the most widely ratified human rights instrument in the world right now. So it's a condition to sign this document, the UDHR, the Universal Declaration on Human Rights, is a condition to be a member of the UN. So at least 193 countries have signed on to these to this human rights document, right? So let's look a little bit about the UDHR and what rights it contains. So it contains, for instance, the right to freedom, equality, and dignity and rights, right? The equality and under the law of every individual. So this means that all countries in the world, those coming from different legal systems, Christian, non-Christian, Muslim countries, Protestant countries, atheistic countries like China have signed on to this declaration, right? So they have recognized that there's at least a right to freedom, right? And equality before the law. They have recognized the inherent right to life of the human person. The disagreement comes in the exceptions to the right to life, but they have all recognized that the right to life is one of those unalienable rights that every individual enjoys, right? The prohibition of slavery has been recognized in the UDHR as well. So this means all nations have reached a consensus that slavery is unlawful under international law, right? And when I teach international law, my students usually say, oh, well, so many countries are actually practicing slavery, So, you know, aren't they being hypocritical? And my answer to that is, in international law, what matters is most what states say than what they do. And sometimes when they practice slavery, they will call it another name. No state will defend slavery saying, oh, yes, we are in favor of slavery, or we should have a right to own slaves, right? And the United States Supreme Court actually has a now overturned decision, Dred Scott, which held that there was a right to property in owning a slave. But that changed all after World War II when the UDHR was passed, and no state would say that now. So states that practice it just normally use another name for it, forced labor, right? Or the like. The prohibition of torture is also considered a jus cogens norm. The ICJ has said this. The International Court of Justice has said that the prohibition of torture is a jus cogens norm because of the wide ratification of the Convention Against Torture, because of the wide acceptance among countries in the world that torture is illegal, right? So what do you say of countries that practice torture? And you know that, and we know that many countries practice torture today, right? I'm going to talk about just an example from my own country, right, where I think there's a big agreement that torture should be unlawful, that torture is unlawful, but when academics suggested the legalization of torture, they didn't call it that, right? So they suggested the legalization of waterboarding, for instance, as an interrogation technique for terrorism suspects. And this was seriously suggested by Harvard professors, by high-ranking politicians suggested, let's legalize torture, waterboarding, right, for certain terrorism suspects from whom it is impossible to obtain information in any other way, right, and where national security is at stake. Well, they didn't call it torture, right? So for them, it was not torture. And there were papers written about why waterboarding was not considered torture. But the United States still believes that torture should be prohibited. And even countries that reportedly practice it still believe that torture is illegal, right? Like Pakistan, let's say, or Saudi Arabia, which are known to have very strict penalties on criminal offenses. So the UDHR is full of general principles of the law, which are natural law principles that are recognized by many nations, religious, non-religious, Christian, non-Christian, all nations of the world, basically, except for the few nations that are not yet members of the United States, and those are less than 5, right? Other rights recognized in the UDHR include the prohibition of exile, for instance, of exiling an individual from their own country without due process, right? Or the prohibition of arbitrary arrest. An interesting provision in the UDHR is the right, and the language is, the exact language says, the right of women, of men and women to marry, right? So the right to marriage is recognized internationally as a universal right, right? A right of men and women. It's not an individual right. It's not considered an individual right, but a right of men and women. So that's interesting language used in the UDHR that every country has recognized. The right to property. Even socialist countries have conceded, have recognized that there is at least a right to private property, right? That some individuals may have it, and a limited, maybe limited right to property, but that a right to property exists. And of course, political rights, right? So the right to vote, to be elected. These are concrete natural law norms, right? So they come not from the faith, but they come simply from inherent truths that are recognized by people of all cultures of all religions or no religion at all, right? This is why they're called natural law norms. And that they have been codified here. So I think the UDHR is a good example of that. And just last, the right to religious freedom is one of the rights recognized in the UDHR as well. So the right that every individual should be able to practice their own religion without interference from the state, right? Without being forced to convert or forced to abandon their religion altogether. So this is another important right included in the UDHR. The Vienna Convention on the Law of Treaties also provides for the existence of these natural law norms. Article 53 of the Vienna Convention says, treaties that conflict with a peremptory norm of general international law are void, right? So they speak of that category of peremptory norms of international law, of general international law. Later on, the ICJ has called these norms jus coens norms. So jus coens means peremptory norm, so a norm that is obligatory to every state, regardless of whether or not they have passed a treaty on it, regardless of whether or not they recognize it in their own domestic law, regardless of whether or not a norm of customary international law has been recognized in that direction. So, so natural law can be very concrete. This is not just a philosophical idea, but you can actually find it in international human rights instruments, such as the Vienna Convention on the Law of Treaties, which is one of the most ratified treaties in history, which is a treaty about the law of treaties, right? So it speaks about those norms of jus coens as peremptory norms, so norms that have a higher level, right? A higher authority than any other norms, than treaty norms, that customary norms, or any other norms. So one may ask oneself, so what are these jus coens norms, right? So there's many UN documents, referring to them, defining them. But I think the best list probably of jus coens norms can be found in international court recognition, so in international court decisions. So what are those? First of all, the prohibition of aggressive use of force. So the UN Charter, which is also adopted by all countries in the world that belong to the United Nations, also need to subscribe and accept in full to the UN Charter. The UN Charter prohibits aggressive use of force, so acquiring territory by military force, the crime of aggression, right? Attacking another nation for the purposes of acquiring their territory or annexing their territory. Even countries that have done it agree to this, right? To give you an example, with the current situation in Ukraine, when Russia has annexed Crimea or southern and eastern Ukraine, it didn't call it aggressive use of force or crime of aggression, it called it reunification, right? So what that means is they still believe that the crime of aggression is a crime, right? They just disagree that this instance, that their actions are aggression. And of course, that has been, their annexation of Ukraine and the Donbass region has been recognized as aggression by NATO countries and by the international community. But they haven't called it that, right? So this is clear in the UN Charter, which prohibits aggressive war or war for, again, the purposes of acquiring territory or depriving a country of its political independence. Another right that has risen to the level of a jus coens norm is the right to self-defense, the right to defend, and this is about countries more than individual, because individual rights to self-defense are contemplated in every single country in their national law, right? The right to defend one's own life. But here, the right to defend one's own country is also considered a jus coens norm. So countries are not required to just stand by and watch their country being taken by another, right? They do have a right to defend themselves, even using force, even through armed conflict. The prohibition of genocide is now recognized as a jus coens norm, especially after World War II. It gained that status of a jus coens norm, meaning a norm recognized by every nation regarding and binding on every nation regardless of whether or not they have signed on to the Genocide Convention. And most countries in the world have signed on to the Genocide Convention, but there's a few that haven't. Even those countries are bound by this prohibition, though. So genocide can never be, so this is the international community reaching the conclusion that genocide is never acceptable under any circumstances, right? And international courts have recognized this as a binding jus coens norm, regardless of whether or not states have ratified treaties on it, have prohibited it in their constitutional law or in their domestic law. It's a higher ranking norm, right? Another example is the prohibition of slavery and the slave trade. So this, in the past, before World War II, was practiced in many countries, right? But even though it was practiced, that doesn't mean that it was accepted as lawful, right? Even in the American Constitution, and the United States was a country that practiced slavery for hundreds of years, right? Became very rich because of it. But even in the U.S. Constitution, which was adopted at the time during the time of slavery, where some of the founders of some of the Constitution drafters were slave owners themselves, even there you can see that they had a plan to abolish slavery eventually. And they never talked about slavery as a right to own slaves. They talked about kind of a necessary evil. And they provided for a period of time by which slavery would end, right, when it was no longer necessary for the nation's economy. So the prohibition of slavery is today, or the slave trade, because some countries euphemistically called it the slave trade instead of slavery, is now considered one of those high-ranking jus coens norms, right, more important than any other norms. Unwritten, self-evident laws that apply to every country, again, regardless of whether they have treaties on it. The prohibition of piracy is one that my students are always surprised about, but this was one of the first norms to acquire the jus coens statute. Why? Because piracy was very common in past centuries. There's still some piracy now in some African nations, but it's very rare. In the past, this was a very common form of organized crime, basically, that deeply affected commerce, especially commerce in the seas, right, between nations. Pirates would steal and take over these ships, and in some cases, they acquired so much power that they even ruled nations, right? Like in the Caribbean, some pirates became so powerful that they even became heads of states temporarily of some nations. So this was considered a serious form of organized crime in the past. It affected nations economically so badly that nations have reached an agreement, and this has been recognized even by the Supreme Court, that piracy is prohibited under international law and that it is a jus coens norm, right? That this means no country can pass a valid law that would permit piracy. So let's say that a country thought that this was an acceptable way to promote their economy. Well, that law would be void under international law if they tried to pass a law that promoted piracy. And finally, just another example of a jus coens norm would be the prohibition of racial discrimination and apartheid. So this would mean racial discrimination in the form of segregation, right? So segregating populations from different ethnicities in let's say, walled communities, walled ghettos, not allowing interracial marriage, not allowing people of different races to use similar facilities, not allowing access to education for the children of another race, for instance. So apartheid has also, racial discrimination in the form of apartheid has also reached that status of a jus cogens norm. And we have several cases in international courts, like the Belgium v. Senegal case, the Germany v. Italy case, which recognize the existence of these peremptory norms of jus cogens, which are really rooted on the natural law, right? So remember the natural law, and I think there's a lot of misunderstanding about it. Oftentimes people believe, oh, the natural law is just a way to codify Christian principles into the law. But it's actually not. The natural law is a lower threshold than Christian morality, right? Christian morality requires us to love our neighbor, to worship God in a reverent way, right? And I don't think any Catholics or Christians expect the law to command that, right? That shouldn't be, we don't expect that that would be a lawful commandment. So natural law is a lower threshold than that. And it is just basic, again, respect for certain crimes that are seen as so grave that they are unacceptable under any religion, under any culture, or historic circumstances, that no historic circumstances would make them all right. Like slavery again, like piracy, like genocide. No circumstances would make these acceptable under international law. So anyway, I think I just wanted to talk about these important source of international law, which is the general principles of international law, because these are not static and they are likely to develop in the future. In the future, international courts and international treaties are free to find more jus cogens norms, to determine that some norms have acquired that status. And international law is always changing and developing, so more norms could be included in this list. For instance, there's a push for the prohibition of nuclear weapons to be included in this list, although that's very unlikely that it would reach jus cogens status anytime soon, just because there's so much objection to it. But the prohibition of drug trafficking, for instance, has a lot of consensus. It could reach the status in the future if treaties were passed on it, and if enough countries considered that this is a jus cogens norm. Children's rights might also raise to or be brought to the level of jus cogens norms in the future. For instance, the Inter-American System of Human Rights has found that the juvenile death penalty, so applying the death penalty on adolescents who committed grave crimes while they were underage, has now acquired the status of a jus cogens norm, and they said this in the Michael Dominguez case. However, this is more of a regional principle of international law. The juvenile death penalty is still allowed in Asia, for instance. So, and not considered unlawful. So it takes a while for norms to acquire this important status, but international law is developing, and more norms can be added to this list in the future. So this is an important, I think, tool for those who believe in the natural law to start codifying, perhaps doing the work of codifying general principles of international law, which is just another norm, another name for natural law norms, and identifying these areas of consensus, of international consensus. So anyway, thank you for this opportunity to speak about one of my favorite subjects in international law, and thank you for listening.